Hi, I'm Patricia Louise Nelson, attorney with 2 Spruce Law in Bend, Oregon. I keep saying, make sure you have an experienced estate planning attorney draft your documents or there could be problems. Well, what could go wrong? I want to talk about 3 circumstances that come up in our probate practice when it's kind of too late to try to fix the problem so that we can avoid them. First problem is documents that are not properly witnessed. At home, someone writes up an estate plan. It says, I give Joe this and Mary that and Jose the other thing. And it's signed. Maybe it's notarized. Under Oregon law, to qualify as a proper will, it has to have 2 signatures, 2 witnesses. So the person who created the document needs to sign, and then 2 other people need to watch them sign and then attest, swear, that they saw them, the person creating the will, sign the will. If only one person saw, it's not enough. Luckily, often people have it notarized, which means the notary is a witness, and sometimes they have another person watching the notary notarize it. Then we have 2 witnesses. And with a little bit of extra work, we can document that document as having been properly witnessed. Often, however, you find the document after the fact. Maybe it was notarized, maybe it wasn't. Notarization is not required and it's not important. The fact that it's signed is important. Under a relatively new Oregon law, we can sometimes get those purported wills approved by the court, but it requires extra notice, longer waiting periods, and there is expense involved in having the attorneys prepare the special petition to get that unusual document approved as the will. So, 2 witnesses all the time for it to qualify as a will. Another common problem is when people write on their documents. They have a document in place, maybe it was prepared by an attorney, maybe several years ago, life has changed, their family has changed, the document doesn't serve them anymore. So instead of going to an attorney to get an updated document, they cross out someone's name and write in somebody else's name. I don't want that person to serve as personal representative. I want this other person to serve. I don't want that person to get my house. I want this other person to get my house. Don't do that. It creates legal limbo. Did you intend to revoke the entire will, which is the historic response to writing on part of a will? I even had one matter in which the person who died, who had created the will with an attorney, went through with an X-Acto knife and cut out parts of the will and threw it away and wrote in above. Because I guess he knew better than crossing out the will. Using an X-Acto knife to remove part of the will is no better than crossing part of it out. You end up in legal limbo, and legal limbo is expensive. You'll probably you will get out of it one way or another. It may not be what you were thinking was going to happen, but why go through the expense when you can just have your estate plan properly updated by an attorney? And the last thing that can happen is sometimes attorneys who have a very general practice, maybe they're in a small town and they do everything, create a will. And maybe that will has some underlying assumptions that experienced estate planning attorney who really is more focused on estate planning would have avoided. I had one attorney prepared an estate plan that said everything goes to my son. And then it didn't say anything else. But the son died before the mom. Leaving us looking for, did the son have children? We ended up benefiting people who mom had no intention of benefiting. But that was how the Oregon laws filled in the gap, given the fact that the assumption was son would outlive mom. And that's a fair assumption. Children are supposed to outlive their parents. But let's not prepare estate plans that rely on that assumption. Another example of an attorney-prepared estate plan that really didn't work out all that well was there was a will that said everything goes to A, B, C, and D equally. And then there was a codicil, which is an amendment to a will that said I revoke all of that section that said A, B, C, and D get everything equally. I revoke that entire section and I give 40% to A, 30% to B, and 10% to C. Now, if you did the math, we had 40, 30, and 10. That's not 100%. So now we have a will that covers part of the overall assets of the estate and leaves a gap as to who gets the rest. There were 3 choices of how to proceed with that. One is to go with intestate succession, one was to go with the original will's plan, and one was to go with an expansion of the amended will's plan for who got what, but more each. So we asked the family. They decided that following the original will was closest to the decedent's intention. So we asked the court for permission to fill the gap as to that uncovered part of the estate plan with the original will plan. And we had to give notice to everybody who would receive assets if we went with intestate succession. We had to give notice to everybody who would receive assets under the amended plan and under the original plan. Give everybody an opportunity to object, which is usually 21 days, and then ask the court for authority to do what we wanted to do, and the court gave it to us. That's a lot of money, it's a lot of time, and frankly, it's a lot of stress for my clients. So let's make sure your estate plan is all cleaned up. Let's get this done together.